Hello, welcome to the EPG Pathshala. I am Nupur Joshi, Research Scholar in Division of Forensic Science, Galgodias University. Today, I am going to discuss with you the Indian Evidence Act Section 45, 46, 47, 48, 49, 50 and 51, Cr.P.C Section 293, Expert Witness and Admissibility of Evidence. So, first of all, we will discuss about the Indian Evidence Act 1872. The Indian Evidence Act originally passed in India by the Imperial Legislative Council in 1872 during the British Raj. It comprises a set of rules and allied issues governing admissibility of evidence in the Indian courts of law. This act introduced a standard set of law applicable to all the Indians. The law is mainly based upon the firm work by Sir James Fitz-James Stephen, who could be called the founding father of this comprehensive piece of legislation. The Indian Evidence Act 1872 is divided into 3 parts and has 11 chapters and 167 sections. This act came into force on 1st September 1872. After independence of India on 15 August 1947, the Act continued to be in force throughout the Republic of India and Pakistan, except the state of Jammu and Kashmir. Then, the Act continues in force in India. Few important sections of the said Act are discussed below. Section 45, Opinion of Experts. When the court has to form an opinion upon a point of foreign law or of science or act, or as to identify of handwriting or finger impressions, the opinions upon the point of persons specially skilled in such foreign law, science or art, or in question as to identify of handwriting or finger expressions are relevant fact. Such persons are called experts. Illustrations. The question is whether the death of A was caused by poison. The opinion of expert as to the symptoms produced by the poison by which A is supposed to have died are relevant. B. The question is whether A at the time of doing a certain act was, by reason of unsoundness of mind, incapable of knowing the nature of the act, or that he was doing what was either wrong or contrary to the law. The opinions of experts upon the question whether the symptoms exhibited by A commonly show the unsoundness of mind, and whether such unsoundness of mind usually renders persons incapable of knowing the nature of the acts which they do, or of knowing that what they do is either wrong or contrary to the law, are relevant. C. The question is whether a certain document was written by A. Another document is produced which is proved or admitted to have been written by A. The opinions of experts on the question whether the two documents were written by the same person or by different persons are relevant. Comments. Conflict of opinion of experts. When there is a conflict of opinion between the experts, then the court is competent to form its own opinion with regard to signatures on a document. The Kishan Chand versus Sita Ram AIR 2005 PNH 156. Expert Opinion Admissibility. Requirement of expert evidence about test firing to find out whether double barrel gun is in working condition or not. Not necessary. Jarnail Singh versus State of Punjab AIR 199 SC 321. The evidence of a doctor conducting post-mortem without producing any authority in support of his opinion is insufficient to grant conviction to an accused. Muhammad Zahid versus State of Tamil Nadu 199 Cr.P.C LJ 3699 SC. Opinion of to be received with great caution. The opinion of a handwriting expert given in evidence is no less fallible than any other expert opinion. adduced in evidence with the result that such evidence has to be received with great caution. Ram Narayan versus State of Uttar Pradesh. Section 46. Facts bearing upon opinions of experts. Facts not otherwise relevant are relevant if they support or are inconsistent with the opinions of experts, when such opinions are relevant. Illustrations. The question is whether A was poisoned by a certain poison. The fact that other persons who were poisoned by that person exhibited certain symptoms which experts affirm or deny to be symptoms of that poison is relevant. Next, the question is whether an obstruction to a harbour is caused by a certain sea wall. The fact that other harbours similarly situated in other respects, but whether there were no such sea walls, began to be obstructed at about the same time is relevant. Comments. Admissibility. The science of identification of footprints is not a fully developed science, and therefore if in a given case evidence relating to the same is found satisfactory, it may be used only to reinforce the conclusions as to identify of a culprit already arrived at on the basis of other evidence. Muhammad Aman versus State of Rajasthan, 1997 for Supreme 635. Section 47. Form an opinion as to the person by whom any document was written or signed. The opinion of any person acquainted with the handwriting of the person by whom it is supposed to be written or signed, that it was or was not written or signed by that person is a relevant fact. A person is said to be acquainted with the handwriting of another person when he has seen that person write or when he has received documents purporting to be written by that person in answer to documents written by himself or under his authority and addressed to that person, or when in the ordinary course of business documents purporting to be written by that person have been habitually submitted to him. Illustration. The question is whether a given letter is in the underwriting of A merchant in London, B is a merchant in Calcutta who has written letters addressed to A and received letters purporting to be written by him. C is B's clerk whose duty was to examine and file B's correspondence. D is B's broker to whom B habitually submitted the letters purporting to be written by A for the purpose of advising him thereon. The opinions of B, C and D on the question whether the letter is in the handwriting of A are relevant, though neither B, C nor D ever saw A write. Section 48. Opinion as to existence of right or custom when relevant. When the court has to form an opinion as to the existence of any general custom or right, the opinions as to the existence of such custom or right of persons who would be likely to know of its existence if it existed are relevant. Explanation. The expression general custom or right includes customs or right common to any considerable class of persons. Illustration. The right of the villagers of a particular village to use the water of a particular well is a general right within the meaning of this section. Section 49. Opinions as to usages, tenants, etc. when relevant. When the court has to form an opinion as to the usages and tenets of anybody, of men or family, the constitution and government of any religious and charitable foundation, or the meaning of words or terms used in particular districts or by particular classes of people, the opinions of persons having special means of knowledge thereon are relevant facts. Section 50. Opinion on relationship when relevant. When the court has to form an opinion as to the relationship of one person to another, the opinion expressed by conduct as to the existence of such relationship or any person who, as a member of the family or otherwise, has special means of knowledge on a subject is a relevant fact, provided that such opinion shall not be sufficient to prove a marriage. In proceedings under the Indian Divorce Act 1869 or in prosecutions under section 494, 495, 497 or 498 of the Indian Penal Code. Illustrations. First, the question is whether A and B were married. The fact that they were usually received or and treated by their friends as husband and wife is relevant. Next, the question is whether A was the legitimate son of B. The fact that A was always treated as such by the members of the family is relevant. Now comments. Contradiction in evidence or relationship of witness of trivial nature, not material in a partition slit. Gohari Das versus Sanlita Singh, AIR 199. Section 51. Grounds of opinion when relevant. Whether the opinion of any living person is relevant, the grounds on which such opinion is based are also relevant. Illustrations. An expert may be given an account of experiments performed by him for the purpose of forming his opinion. The Code of Criminal Procedure 1973, Section 293. Reports of certain government scientific experts. Any document purporting to be a report under the hand of a government scientific expert to whom this section applies upon any matter or thing duly submitted to him for examination of analysis and report in course of any proceeding under this code may be used as evidence in any inquiry, trial or other proceeding under this code. The court may, if it thinks fit, summon and examine any such expert as to the subject matter of this report. Where such expert is summoned by a court and he is unable to attend personally, he may, unless the court has expressly directed him to appear personally, repute any responsible officer working with him to attend the court, if such officer is conversant with the facts of the case and can satisfactorily depose in court on his behalf. Next, this section applies to the following government scientific experts, namely any chemical examiner or assistant chemical examiner to government, the chief inspector of explosives, the director of the fingerprint bureau, the director of the Hafkin Institute, Bombay, the director, deputy director or assistant director of a central forensic science laboratory or a state forensic science laboratory, the serologist to the government, expert witness. A person whose level of specialized knowledge or skill in a particular field qualifies them to present their opinion about the facts of a case during legal proceedings. In other words, an expert witness can be defined as a person whose opinion, by virtue of training, education, certification, experience or skills, technical, scientific or other, is exported by the judge as an expert. An expert offers special expertise in a particular field. As an expert witness, however, he or she needs to offer additional skills and abilities, courtroom skills and report writing, for example, which can be enhanced by training and developed over time. When in court, the expert witness methodologically presents opinion evidence based on evidence of fact. The subsequent report which the expert witness would prepare would be written within a specified time scale in compliance with specific legal guidelines. Admissibility of evidence. Admissible evidence is any document, testimony or tangible evidence used in a court of law. Evidence is typically introduced to a judge or a jury to prove a point or element in the case. Criminal law. In criminal law, the evidence is used to prove a defendant's guilt beyond a reasonable doubt. Relevance. For evidence to be admissible, it must tend to prove or disprove some fact at issue in the proceeding. However, if the utility of this evidence is overweighed by its tendency to cause the fact finder to disapprove of the party it is introduced against for some unrelated reason, it is not admissible. Furthermore, certain public policy considerations bar the admission of otherwise relevant evidence. Reliability. For the evidence to be admissible enough to be admitted, the party proffering the evidence must be able to show that the source if the evidence makes it so. If evidence is in the form of witness testimony, the party that introduces the evidence must lay the groundwork for the witness's credibility and knowledge if he attests to. Hearsay is generally barred for its lack of reliability. If the evidence is documentary, the party proffering the evidence must be able to show that it is authentic and must be able to demonstrate the chain of custody from the original author to the present holder. The trial judge performs gatekeeping role in excluding the unreliable testimony. The United States Supreme Court first addressed the reliability requirements for experts in the landmark case Daubert versus Merrill Doe Pharmaceuticals. The court laid out 4 non-exclusive factors that trial courts may consider when evaluating scientific expert reliability: whether scientific evidence has been tested and the methodology with which it has been tested, whether the evidence has been subjected to peer review or publication. Next, whether a potential rate of error is known, and whether the evidence is generally accepted in the scientific community. Admissibility and inadmissibility. The evidence generally falls into 4 categories: admissibility and inadmissibility. The evidence generally falls into 4 categories. They are: first, real; second, demonstrative; third, documentary; and fourth, testimonial. The real evidence is any actual object that was directly involved in an event in that case. It could be the weapon used to murder a victim, like a gun or a hammer, or a tool used to break into a house, like a crowbar. Next, demonstrative. Evidence, on the other hand, is an illustration of evidence, something like a map of the crime scene. Also a type of real evidence, describes letters, contracts, newspapers or anything that contains human language. The next, that is testimonial or anecdotal evidence, is oral or written evidence from victims, suspects and witnesses involved with that case. All of the above types of evidence need to follow the rules of admissibility, which are there to make sure that anything introduced to the court as evidence meets 3 criteria. The first are relevance, the second materiality, and third, that is competence. Relevant evidence proves or disproves the fact of a crime, but it does not necessarily prove anyone's guilt or innocence. It is simply a broad term that describes any piece of evidence related to the case. A tool stained with the suspect's blood might be relevant. For example, but so is the person who sold that tool to the suspect. However, testimony from a toddler discussing a broken house contract would be deemed irrelevant and therefore inadmissible because a child would be too young to understand the case. Material evidence, on the other hand, needs to prove an essential fact of the case. For example, if a lawyer attempts to prove that the drapes in the room of a murder scene were blue, chances are a judge will deem such evidence immaterial. The room itself may be relevant to the case, but it's likely the color of the drapes doesn't have anything to do with the murder. Finally, competent evidence is an object or testimony proven to be reliable, like matching fingerprints, the results of a DNA test, or an expert on footwear impressions. An expert giving an opinion that isn't generally accepted in his field, on the other hand, is neither competent nor admissible. There's an endless amount of inconsistency and several exceptions, but one of the most important rules of evidence is the hearsay rule. This rule prohibits the second-hand testimony or evidence of he said, she said variety during a trial. If an eyewitness to an accident tells his friend the details after the event, the eyewitness's friend's testimony would be hearsay and considered as inadmissible. A judge can dismiss evidence for several other reasons too. A presentation will take an unnecessarily long time, upsetting photographs will unfairly enlighten a jury, or forensics experts might have gathered evidence illegally. However, the main reason for declaring inadmissibility is to make sure evidence is reliable and fair to both the sides of a case. That's all for this section. Thank you.